Thank you. Please be seated. Good morning. We're here for oral argument. Do you have a sign-in sheet? Is there a sign-in sheet? No. Yes. Okay. Could you hand that up? Thank you. We're here for oral argument in case of James Michael Humphry et al. Versus the State of Arizona. Case number 1 CACV 160570. Council would remind you that these proceedings are being video and audio recorded, so we ask you to please identify yourselves and your clients at the beginning of your arguments. Each of you have 20 minutes. Now we understand that we have a clock problem this morning. Apologize for that. The bailiff will do her best to she will keep track of the time and notify you. You'll have to keep an eye out for that, but I understand that she'll signify when there's 5 minutes left. Now, as far as dividing time for the cross appeal, we'll leave that to you to monitor that time and give you a little bit of leeway there, but probably not too much. So, I mean, if you're able to watch on your phone or whatever, that'd be helpful. So, again, for rebuttal purposes, if you want to retain some time, you need to reserve that time, and we'll keep that for you. And the same would go on that same principle would apply for the cross bill. Please keep in mind that we've read the briefs, we've discussed the case in conference, so we're familiar with the facts and procedure. You want to keep that in mind in the limited time you have. With that, counsel for appellant, you may proceed.
Good morning. I'm Nicholas Aceto, counsel for the State of Arizona. With the limited amount of time we have this morning, I'd like to focus on two issues: absolute immunity and accrual of the statute of limitations. Of course, I'd be happy to answer any other questions on the remaining issues that you may have. I plan to reserve at least 5 minutes for rebuttal, and I'll keep track of my time. With that, I'll start with absolute immunity. The legislature has afforded immunity to government entities for making fundamental policy decisions. Those decisions involve the weighing of risks and gains, choosing one course of action over another, and selecting particular criteria. The adoption of specified criteria for determining whether and where to install a median barrier undoubtedly qualifies. Litigants are prohibited from second-guessing those government policy decisions. But the government's immunity does not end there. Our court's jurisprudence extends administrative immunity to allegations of negligence that inevitably flow from a policy-making decision. Here, the allegation is that the state negligently failed to install a median barrier on Interstate 10 at milepost 171.4.
Counsel, I'd like to stop you there for a second.
Sure.
Let's talk about the standard of review. On the immunity claim and the notice of claim issue, both of those are denials of summary judgment. Are we reviewing these two issues based upon denial of summary judgment, based upon denial of motions for judgment as a matter of law, or based on denial of motion for new trial? Help us understand that.
Sure. With the immunity issue first, that resulted from an order denying our motion for summary judgment. That ruling would be reviewed de novo. We subsequently renewed that motion under Rule 59 in a motion for new trial. Those motions are typically reviewed for an abuse of discretion. However, the issue in that motion is the same. It involves immunity. And whether or not the state is entitled to immunity is a question of law that is reviewed de novo. So again, for that issue, everything is totally de novo review.
But you would agree with me that generally speaking, that denials of summary judgment are not appealable. You cannot raise those on appeal.
Generally, that is true, Your Honor. There are exceptions, however, if it's a pure question of law. And again, immunity is a pure question of law, and we did renew this after trial, so we sort of bundled it again. So I believe that this is a fair issue with de novo review. As far as the accrual issue, same thing. This was raised initially on summary judgment. We raised it again in a Rule 50 motion, both before the verdict and after the verdict. Sufficiency of the evidence is reviewed de novo. One of the issues and the primary issue in that argument is that the claims accrued as a matter of law no later than the date of the original notice of claim. That I believe that is a question of law and something that this court can review de novo under its cases. Rogers and Little, that similarly held that a filing of a settlement demand or a board complaint as a matter of law, the claim accrues. So again, I believe both issues are a straight de novo review for this court.
Understood, but does that mean that we need to comb this record, I mean, the trial record, carefully? I mean, we're still assuming every fact in favor of the appellee, right? In favor of the plaintiffs here.
Sure. All inferences are
on both issues.
Right. And the standard for summary judgment is no reasonable jury could find in favor of the plaintiff. One. Two, there has to be material, genuine issues of material facts. So if you take the material issues, our position is that they are undisputed. And because they're undisputed as a matter of law, we're entitled to summary judgment.
For example, let's discuss the notice of claim for a bit.
Okay.
What is the weakness, or if you, from your point of view, the problem with the concealment theory, the fact that the state did have the crash data and did not disclose that? Why isn't that a jury question, a fair issue for the jury to decide?
Well, let's assume that is a jury question. Our position is that the claim accrued before that. And once a claim accrues, subsequent events, alleged fraudulent concealment, even if true, even if there was evidence to support that, that does not restart the clock or erase from the minds of the plaintiffs the information that they had.
For the record, when did the claim accrue? Let's not just throw that out there.
Sure.
You tell me, when did the claim accrue?
Well, I think we've got 3 accrual points that you could choose from. The first is the date of the accident or shortly thereafter, which was May 2008. All of this goes through 12821.01b, the statute that defines when a claim accruals on claims against the government. You only
Let's
need.
pretend that we haven't looked at that.
Okay, that two elements.
Tell me
One,
when it accrues.
they had to have known that they were injured, and that they had to have known, or reasonably should have known, the condition that caused or contributed to their injury. Here, the first accrual point is the date the date of the accident or shortly thereafter. This is a cross-median accident. They knew on the day of the accident that they lost their spouse and mother. And with a cross-median accident, it's pretty obvious that the absence of a median barrier at least contributed to that injury. That's the first accrual point. The second accrual point would be in August or September of 2008. That's when we have Michael Humphry, who testified that he knew then that the absence of a median barrier likely caused their deaths. You've got Lynn Quinn, who also testified that he knew about that time, that had there been a median barrier, this would not have happened. That was August, September 2008. So
let's pause on that August date, because I understand the plaintiffs to be arguing that it's unclear as to whether that accrued before their alleged concealment, because they're saying that Mr. Hammond was, when he made the request from ADOT, that gave rise to the concealment theory at around the same time. And they're saying it's a fuzzy time period, whether you had Mr. Humphrey's knowledge, awareness of the article at that time, at the same time as the Hammond's making the inquiry from ADOT, and that wraps itself up for a nice question for the jury. What's wrong with that theory?
Yeah, that's a little bit fuzzy, but let's go back and look at exactly what Hammond testified to. And that was that he started his conversations with Nancy Crandall in about the August time frame. They never pinpointed when Nancy told him that they didn't have that information. And in fact, the testimony is that they had a continuing dialogue between Hammond and Crandall up until November of 2008. So any ambiguity in there, they haven't established that started before the accrual, certainly not shortly after the accident in May, not that they were deprived the information in August or September, because the evidence is that there was a continuing dialogue up through November. But even assuming that you can say that some fraudulent concealment began in about August or September, any tolling for fraudulent concealment stopped in November 2008 when they filed their original notice of claim. Cases like Walk versus Ring, Arizona Supreme Court, says that once they have the actual knowledge, any tolling beforehand stops. So even assuming that there was tolling up until that original notice of claim, once they filed that notice of claim, any tolling would have been lifted because they knew at that point, if you look at that original notice of claim, it was filed on behalf of all of the plaintiffs. Not only was it filed on behalf of all the plaintiffs, but it specifically said that the state was negligent for failing to install a median barrier. It doesn't get more clear than that.
Was this, and that's exactly where I wanted to go, was the specificity adequate within the November 7th notice?
Absolutely not. And this is a legal question within this issue, is whether it was it complied with the notice of claim statute. The original notice of claim was non-compliant because it did not have a sum certain. If you go back to Deer Valley, that says you can't use approximate terms as far as the demand that you're making. The demand in the original notice of claim said a range of between $5 and $10 million. And if you look at City of Phoenix versus Fields, I believe we cited that case in our brief. That case, it's a Court of Appeals case, specifically said that ranges do not qualify as a sum certain.
Does the lack of specificity as to the number negate the expression of the facts within that same notice of claim?
No, it does not negate the expression of facts, because the facts are the facts. The facts, the facts document the knowledge. So the non-compliant aspect of that original notice of claim bars their claim. That's a mechanism that would bar their claim. But the facts remain what they are, and that was an expression of facts that they knew at that date that the failure to have, or they alleged that the failure to have a median barrier caused the injury. Now, I understand that the Sean Humphry and the Quinn plaintiffs, they argued below, and they argue now that they weren't bound by that original notice of claim that was filed by Attorney O'Hare. And they argue that they're not bound by it because they had no idea that he went out and did that. Let's assume that that's true. What they did know, and what they did authorize, and what they did direct was Attorney Leader to file that supplemental notice of claim in October 2010. And in that in the October 2010 supplemental notice of claim, it specifically says that the prior notice of claim is adequate in all respects, and that they ratified it. They endorsed that. So they authorized their agent, their attorney, to ratify the earlier notice of claim. And they're bound by their principle. They are bound by their agent's actions and their statements.
So is the operative date the date that they ratified the earlier act, or is it the ratification of the earlier act that makes November 7th the appropriate?
November 7th. It doesn't matter when they ratified it, but it's the fact that they did. And they did that for a reason, because they obviously knew that October 2010 was several years after the date of the accident. They were trying to take advantage of the earlier notice of claim for timeliness purposes and wanted to supplement it with to fix the some certain error. But now, when we get to litigating this case, they want to back away from it. This court shouldn't endorse that type of gamesmanship. When you authorize your attorney to make a statement and adopt a prior position, they should be bound by that.
What is the legal significance of the statutory beneficiaries? To what extent are statutory beneficiaries to be treated differently than a statutory plaintiff in a wrongful death action? In other words, did the statutory beneficiaries even need to file a notice of claim here? I mean, if there is no, can there be a claim? I mean, can there be a viable lawsuit or claim, a wrongful death claim, for a statutory beneficiary without a statutory plaintiff?
Yes, I believe
there can be. I mean, doesn't there have to be a statutory plaintiff to bring the action?
Right, to bring the action.
I mean, also the point is, I mean, so does a statutory beneficiary have to file a notice of claim?
Well, the statute says any claimant. They use the word claimant as opposed to the wrongful death statute, I believe, uses.
So the state's position, yes, they do. And assuming that's true, then why isn't it a viable argument that they knew nothing? They knew nothing about, putting aside the ratification argument, put that aside for a second. They didn't know anything. They simply were not aware of the original notice of claim, nor were they aware that there was talk of filing a claim. They didn't know until the actual lawsuit was filed or thereabouts. Why isn't that a classic case of tolling?
Well, there's no event. First of all, only Michael Humphry raises the tolling argument. Only he raises that argument. It doesn't apply to any other plaintiff. But a claimant has an obligation to, well, what they can't do is stick their head in the sand. If you look at Walk versus Ring, that case says accrual begins when they were on notice to investigate whether there was negligent conduct. So they can't.
So the statutory beneficiaries are saying the claim didn't accrue until they were given actual notice
by Mr. Leader, right? That's their position. That they didn't know, or their claim didn't accrue until they were told by their attorney that they had a cause of action. And we cite cases that say that accrual doesn't depend on, one, having all of the facts, two, having an expert opinion on breach or causation, three, knowing the legal significance of the facts.
But again, I go back to how is that a pure question of law? Why isn't this, again, a question for the jury?
Well, it's a question of law whether or not that supplemental notice of claim ratified the early original notice, which brought them all in, tied all the plaintiffs together back to that November 2008 date. That's a question of law. It's the state's position that as a matter of law, those notices of claims effectively triggered accrual of all of their claims. That's a legal question for this court to decide. That's not something for the jury to decide. They can say all they want that they didn't know. But the standard is, did they know or reasonably should have known? And the point of that, it's an objective standard. It's a reasonable standard. So it's not enough just to say, I didn't know. I didn't know that the claim accrued. That's not good enough, because any plaintiff can say that. It's when would a reasonable person have been on notice to investigate. And when you've got individuals like Michael Humphry and Lynn Quinn who said in August or September that they knew at that point that the absence of a median barrier caused the accident, or if they knew, a reasonable person should have known. They all should have known at that date. I'd be happy to answer any other questions on the notice of claim issue, or I can switch gears to the immunity question, which is our primary argument. As I had started my argument, the question this court must decide is whether the absence of a median barrier at milepost 171.4 flowed directly from the state's immune decision to adopt a median barrier warrant. The answer to that question should be yes. There is no median barrier at that milepost because the roadway does not satisfy the warrant criteria for installing one. The median was greater than 75 feet wide, and it had fewer than 3 lanes. And that's where the trial court erred in this case. It denied immunity simply because the state did not robotically say that it was not installing a median barrier at that particular milepost because it didn't satisfy the warrant criteria. But the state's not required to do that, either for milepost 171.4 or any of the other hundreds of mileposts where they're not median barriers.
Is the state required to at least evaluate how many accidents there have been over a certain time period to make that determination? Are you saying that the state's only obligation is to go off the warrant that's based upon 50 feet width or less?
That's right. And they made that decision after careful consideration. They looked at all the options. They considered various median barrier warrants. They rejected an accident history warrant or relying on accident history.
So even if there's 50 accidents in a 10-mile area, a 10-mile span on a highway, which I don't know if that's significant or not. I guess that would have to be plugged into some formula to see how many travelers per day, vehicles per day, et cetera. But assume that there's a large number of accidents. That would not, in the state's mind, that would never become a factor.
No, I mean, they made a policy decision. They made a policy decision, and they stick to that policy decision. If it doesn't fit the criteria, a median barrier isn't warranted to be installed. They don't consider accident history. They only look at the median width. I'm about where I want to be for my rebuttal. I pick these questions up on the back end. Thank you.
Thank you.
Good morning, Your Honors. My name's Tim Aiken from Milwaukee, and John Leader is here also. Mr. Leader is going to handle the 01 immunity, and he's going to reserve 1 minute of rebuttal for his cross appeal on that production issue. I want to point out that as I studied this case, I read the James case 3 times last night, and I looked at the appellant's brief to see how they distinguish James. They not only didn't distinguish it, they didn't mention it.
Refresh our memory. We've looked at a lot of cases over
Sure.
the last few days. Can you refresh our memory on the James case?
James case is the case that involves a dad and a mom. They're divorced. Mom does the procedure appropriately. Dad doesn't. And dad tries to latch on to mom's notices. And the court says, no, every beneficiary is judged on their own, all the way down the line. If my reading of James is correct, and I believe it is, all the discussion about Lynn Quinn is irrelevant. He can blow his own claim, and I'll get to Mike Humphry in a minute. Mike Humphry can blow his own claim, but they can't blow the claims of the other beneficiaries because there's another case, I think the case is Willett, they can't even settle the claim without the other beneficiaries being involved.
They also have to establish the claim, counsel.
Well, but more than one person can be the statutory beneficiary, as I understand it.
Somebody has to establish the claim.
Right.
12.82101 requirement.
Right.
Somebody.
Right, but as far as their knowledge waiving the statute, I don't believe James would allow their alleged knowledge, which I'll get to in a minute, to bar the other claimants. I really don't under James.
So let's assume that's true. So say Mr. Humphrey's claim goes by the wayside and Mr. Quinn's claim both goes by the wayside for failure to comply with the notice of claim statute. You're saying, though, that the statutory beneficiaries, that would survive because that was a jury question as to accrual.
Yes,
Is that
exactly,
correct?
yes.
So help me understand why, if they've signed affidavits as avowing essentially that they knew nothing and essentially did nothing in the 2.5 years in order to ascertain or investigate a claim, why is that a jury question?
Well, I've tried to come up with examples, so I'm going to give you the best one I think. How about the snake? Snake was the proximate cause of this accident. So what if Lynn Quinn finds an article about the fact that we build these walkways for animals underneath the expressways to keep animals off the expressways? And he writes Mike Humphry and says, if only they would have had a walkway for the animals underneath the expressway so this snake could have gone underneath the expressway. Now, would that type of article give someone notice that the state should be building walkways under expressways for snakes? I hardly think so.
Maybe not, but would it give the obligation to at least start inquiring? I mean, to do an internet search, to go talk to an attorney, to talk to an engineer, to talk to a neighbor, a parent, a friend, to talk to somebody about the claim. I mean, here, I don't think we have any of that evidence.
Well, I submit that without any knowledge of a need for a cable median barrier there, nobody could talk to anybody and come up with a conclusion. Remember, the state concedes there's 1,960 miles of open medians in this state on the expressways. Only 360 have cable barriers. 82% do not. 1,600 miles do not. If anything, the fact that there's, even if one says, oh, a barrier could have saved this, there's a lot of things that could save this. Anti-lock brakes could save accidents. That doesn't mean that a car is not made right if it doesn't have it. It took years to develop. Backup cameras, same thing. Front warning collision, same thing. Go back to my era, seat belts. Nash in 49, Ford in 55, Saab in 58. When did seat belts become something that had to be in cars? So what is confused here is the knowledge we have now of 10 or 11 accidents. No one knew that. No one knew that.
So, counsel, was it somebody's responsibility? Is it the potential claimant's right to sit back and say, well, until somebody understood I needed that information and came and gave it to me, I had no obligations at all?
Well,
because that sounds like what you're saying. Because all this stuff was out there, and eventually people discovered it, and with that, then there's a problem. So
well,
how does that?
I don't think the fact that there's an accident and let's posit that they knew, which there's no proof they got the article, okay? And I think the article is a red herring, frankly. But let's assume that somehow they would know about the article. There's nothing about the article that said there's a duty to put cable median barriers on the other 82% of these freeways.
Let's stop right there for a second. is there any, what in the plain language of Arizona statute regarding notice of claim says that you have to make any claim about duty? It says facts supporting an injury.
Well,
And a claim.
a claim. And what is a claim? Duty, breach, cause damage.
What case law says that duty, breach, causation, and damages have to be included in a notice of claim?
Well, I read Walk as providing that, and all the cases
So
cited
it's
in
not a
Walk.
notice of claim case.
No, but the legislature amended the notice of claim to incorporate discovery rules within the notice of claim for claims like this. That was amended. And then, by the way, the statute was re-amended 2 years ago, and they never made a change to the existing law as it exists under Walk and others. But the problem I have with the idea that just because someone gets killed and something would have prevented that death, that doesn't mean that even is in this situation, that most of the time there should have been one there. Anybody who drives around Arizona knows almost everywhere you go there aren't any cable barriers. Why would anybody assume that the state should have put one there? That's versus it would have been nice if it was there. It would have been nice if 30 years ago we had airbags. That'd be nice too. But there's nothing that says that it belongs there, and the whole...
Shouldn't they have asked you a question?
What are they going to ask? I'm sorry, I'm asking you a question. I shouldn't do that.
Isn't that their responsibility to figure out who they need to ask?
I mean, don't you have to go through the process and then you can say, look, here's what we did. Here is our due diligence. We did A, we did B, we did C, and therefore, Your Honor, this needs to go to a jury to determine when the accrual was, because we did everything reasonably possible. But what an objective person would do.
Or counsel, we're number one.
I mean,
we're the first ones to make this claim.
But that's the problem, is that in order to exercise due diligence, you have to suspect that there's something to investigate. The only ones who suspected it was Lynn and Mike.
But are they not reasonable people? I mean, we're looking at this from a reasonable...
Yeah, they're very reasonable, and...
But I mean, what does a reasonable person do? We can't look at it, so-and-so likes, to do more research versus somebody that doesn't, and we can't evaluate it on that basis. We're looking at what a reasonable person would do under similar circumstances.
The only research that would have made any difference is if someone could find out the number of accidents on that stretch. Otherwise, a cable median barrier is not required there. If they did all the research in the world, they would have read about 84 feet, 50 feet, 75 feet medians, if that's the standard across the United States.
If that's the standard, there can never be the first lawsuit then. There can never be a first time.
Well,
on any stretch of highway, let's say there's no guardrail and somebody goes off the edge, and how would one know whether there should have been a guardrail there on the side to keep me from going off into the ditch? Do I need to know? I mean, you're saying as a matter of law, I would need to know that there were prior individuals that have gone off before me.
I'm reflecting on the question, what research could they do? And I'm saying the only research, according to the record, the only research that would help them would be knowing the prior accidents, which the state affirmatively said, Nancy Crandall, they were occasional. We don't have that information. If you do the research, the key to having a median barrier here is other accidents. None of the other rules are violated. If there aren't other accidents, there's no need for a cable median barrier here, period.
So there's never a first case.
I don't understand that question.
There's no research. There's nothing to support the first case.
Well, the first case comes from a lawsuit once one finds out that there were numerous accidents there.
That was you.
Yeah, that was us in Glazer, yes. Actually, Mr. Zacher deserves the credit for that.
That was this case. It was the first case.
It was the case before this.
Glazer was the very first case.
Was the very
there
first
needed to be a
case.
notice of claim, right? But you knew about those accidents when you filed the notice of claim?
On Glazer, yes. And it came from Mr. Zacher doing the same request for information that Mr. Humphry did, but he got an answer and analyzed it. But the key here is that if you do the research that you propose the plaintiff should do, they're not going to come up with any different answer that 84 feet, you don't need cable median barriers if you have an 84-foot median. That's the rule. The exception is, well, if there's accidents there. And then you have to be able to find out accidents. So how does one find out there's accidents there? One writes ADOT to find out there's accidents there. If it ends up that there aren't substantial accidents there, there's no cable median barrier there. I don't care if Mrs. Humphreys and Quinn died, and I don't care if the Glazer dad and kid died. 2 accidents don't even make a need for a cable barrier. They don't. 84 feet is established as a safe zone in the absence of other crossovers within the reasonable vicinity as per Glazer and as per this case. So whatever research you expect these young people to have made, they couldn't have found out what you're asking them to
We're
find out.
expecting it. I think that the legislature, and we don't make the laws, and but it says what it says, and I don't know that we're trying to put any particular burden other than reasonable.
And I don't think if the state can't show that there was some research that could be done that give an answer of a suspicion, as Walk says, and I can quote it if I take the time. The mere fact of injury is not enough. Let me see. I wrote it down this morning. They talk about. You want to take over on this? Yeah. Okay. My counsel has asked me to step aside.
Okay. All right.
May it please the court, John Leader for all appellees and cross appellants. I have limited time. I want to add a few points on the issue that's being discussed, and I believe that the court is asking the wrong question. The court is getting into the minds of jurors. What about this? What about that? The question before the court is whether this was a jury question. Due diligence is required, and there are good arguments why these plaintiffs may not have been duly diligent. The plaintiff in Walk did nothing to explore the claim, and the court ruled that that was not a lack of due diligence as a matter of law. The question is, was this appropriately a jury question? There are good arguments why maybe the clients weren't duly diligent, but that doesn't mean as a matter of law that they were not duly diligent. And that Walk says that, and it says due diligence is specifically one of the notice of claim and one of the accrual issues that must be a jury question. The court may feel that the Quinns and Sean Humphry were not duly diligent, and I respectfully submit that's not enough. The court has to believe that as a matter of law, they weren't duly diligent, and I don't believe on this record, and in light of the Walk case, you can make that finding. The Stools case, STULCE, says that the common law discovery rule applies to the notice of claim statute and the 1-year statute for the state. So to argue that it's some other discovery rule is just wrong, so Walk applies, all the other cases apply, and again, the issue for the court is, did two trial courts err in saying these are all jury questions? Judge Ronan made that ruling in 2012, and Judge Udall made the same ruling, so we don't have just one trial court saying this is a jury question, we have two. Two sitting, qualified, competent Maricopa County judges who looked at the record, and they both said these are jury questions. Is it a close call? Maybe. But it's under Arizona law, specifically Walk, these are...
Judge Udall provide any kind of detailed ruling, or did he just say, I'm not going to revisit Judge Ronan's ruling?
I believe what he said was, it was either in his November 23rd, 15 ruling, or it may have been the post-trial denial of the motion for new trial. He said, I independently looked at this issue. So,
We'll check that.
Yeah, but I think the record is pretty clear that they both looked at the issue and they both concluded this is a fact question. And I think under Walk and all the other cases, it has to be. So I think if the court bears in mind, I once tried cases in front of Judge John Roll, and Judge Roll once told me, we were going back and forth, and he looked at me and said, Mr. Leader, he who phrases the question wins the argument. And the phrasing of the question is critical. And the question here is, was it appropriate for the judges to let the jury decide? And if you answer yes to that question, we must prevail on this issue. That's the question. And the case law says that for a claim to accrue, and by the way, the state has the burden of proof on accrual, not us. It's their burden of proof. They didn't ask the Quinns any questions at trial on these issues, and they could have. They didn't submit any evidence in the summary judgment proceedings from the Quinns to prove lack of due diligence. It's their burden. And the case law is clear that before a claim accrues, that the plaintiffs must know not only the what, which is the injury, but the who. They need to know that someone did something wrong, and that's the point that my co-counsel was trying to make. It's required that they know not only injury, but that someone did something wrong.
That's
Go ahead.
That's exactly what's explained in November 2018 notice of claim, doesn't it? 2008. Sorry, November 2008 notice of claim. Doesn't it say exactly what you just said?
It says that yes, as to Mike Humphry, yes, and again, it's a fact question. It's a fact question whether the other claimants said, we knew nothing about it. Lynn Quinn, who's now deceased, and the Quinn boys and Sean Humphrey said, we knew nothing about it.
But if
And now,
Humphrey discovered it, clearly the rest of them could have discovered it.
oh, they could have, but again, whether it was reasonable for them not to, Your Honor, is a jury question.
So is it reasonable, again, to sit back and wait until someone comes and tells you something before you claim that you had knowledge of it?
It's a fair question, but it's a jury question.
It's a jury question also to whether they should actually ask their parents whether they've even looked at this.
They're all
whether
jury questions.
Thinking about it.
And I'm sorry for interrupting,
Yeah.
but that's what's unique about Arizona law on this point. They're all jury questions. They're fair points. They're good questions. And
Not
their
always,
arguments.
not Little, not Thompson,
Right.
not those cases. They
Right.
weren't jury questions. Why?
Well, in Thompson, for example, the officer told the plaintiff at the accident scene, there's a pothole that caused your collision.
But in
So in that situation, I think as a matter of law, nobody can reasonably dispute that the plaintiff knew the who and the what.
What
She
about
knew-
the Little case where there was wasn't there seemingly ratification of some that apparently didn't try to disavow from the notice of claim or knowledge? I think Little talks about knowledge is imputed to anybody who gave in an agency relationship. The knowledge was imputed to all the plaintiffs.
Sure, but there's no agency relationship between Lynn Quinn and Mike Humphry, or no agency between Mike Humphry
But
and
the
Sean.
agency between you and your clients when you authored the 2010 notice of claim.
Well, that was after the fact, and that's some. By the way, this argument was never raised in the trial court, and we believe that because the trial court wasn't given the opportunity to address it, that it's waived. But if the court addresses this whole ratification argument,
Don't we have to look at the legal documents before us in order to?
sure,
I mean,
you do, and that's fine. But my
Or
point
you-
is, Judge, it's still a jury question. This is one piece of evidence that maybe the Quinns knew. And then it's a jury question whether, based on their affidavits and their deposition testimony, which the state didn't include in the record, it's a jury question. So here, we have this notice of claim where they filed it in October of 10, and this notice of claim says, you guys knew. We ratify the prior claim notice in all respects. Well,
So if I sat as a trial court judge and decided a case from the bench on a 12-8-2101 objection, I'm wrong because that's a jury question.
on these facts, yes. I believe the two trial courts correctly found it was a jury question. And that's our position. Correct.
Always a jury question. The court can never make a dispositive decision.
No, not always. Like the pothole case. I'm sorry, Thompson, I think. So there are some cases where, as a matter of law, reasonable jurors could not differ. The facts in those cases are different. And the concealment issue is significant as well. It plays into accrual. But again, it's the who and the what. In Thompson, it was obvious someone had done something wrong. There was a pothole there. No one could know. We have an affidavit from Robert Blyle, Dr. Blyle, who testified no one, even traffic engineers, can't know if there's a problem here without knowing the accident history. And if and this is uncontroverted, they could have gotten an affidavit from their expert, but they didn't. So the evidence before the trial courts was uncontroverted that nobody can know if there's a problem unless you know the accident histories. And there's only one entity that has those accident reports, and that's ADOT.
There's an unlimited statute of limitations until someone does a report years later.
No, Judge.
It harks back.
I believe there's a statute of repose in Arizona, and I frankly have never dealt with it. I don't know what it is.
When would it begin to run?
Well, I guess in this case it would begin to run when it did, when Mr. Humphry learned about the prior accidents. And again, Judge, it's a jury question.
But let's say that he didn't learn about the prior accidents for 8 years.
Well, then I think, I don't want to speculate, Your Honor, and it would potentially be a different case if he learned about
But we're
the accidents.
establishing some, and this is a pretty significant case here on what the statute means and what the statute contemplates, and for us to say that no investigation because somebody says that no reasonable person could have known until those crashes happened, that's a pretty significant theory.
It is. It could be a lack of due diligence, but it's still a jury question. And the same thing happened in Walk. The plaintiff did nothing, and the court said it needed to be a jury question. So that is the issue.
Plaintiff did nothing because her dentist essentially lied to her.
Well, and I submit to the court that if
It was fraudulent concealment.
as was the concealment here, and
How was it fraudulent?
because, as Your Honor pointed out, they had the crash reports, and they told Mike, and not only we don't have them, but they also misled him and say, oh, they're only occasional. They were trying to throw him
Did
off.
they say they don't have them?
Yes.
What document can you point to where they said they definitively
It's
had no
in our
issue?
statement of facts. We filed it December 8th of 2011 in the summary judgment pleadings. We attached the deposition testimony of Sean Hammond relating to his conversations with Nancy Crandall, who was the go-to person for traffic data at ADOT. He's an employee of the state. He worked for the Governor's Office of Highway Safety, and he says she has this information. I've gotten this type of information from Ms. Crandall before. He testified ADOT has this information. Tony
Did he
Boyles.
tell Mr. Humphry that?
He did. They have it, but
How's that not noticed to Mr. Humphry?
well, it's notice that perhaps they're not being honest, but it's not notice of the information he needs to proceed. ADOT is the only entity that has these reports. Where else are they going to get it from? Your Honor, I know I can't ask the
Just
court.
didn't have the reports?
DPS probably had the reports, so presumably Mike could have asked DPS, and I think that's a jury question whether it was reasonable only to ask ADOT. Mike is a career public servant. He went to his friend who worked for the governor's office. He went to the best place he could, the best resource he could find.
Okay.
All right, may I have 1 minute to discuss
You
immunity?
may, yes.
The problem with immunity is that the state did not make the decision, or they failed to prove that they made the decision they claim they made. They're claiming they decided back in '99 not to install barriers based on accident histories. Although it's de novo review, it's not a level playing field. It's they have the burden of proof, and they must prove immunity clearly applies. And they did not prove that immunity clearly applies. All the evidence shows that, in fact, it was the state's policy to install median barriers based on accident histories. If you look at the testimony of Otterness that we provided, from the prior Glazer case, the state produces Otterness as their median barrier policy witness, and Otterness says it's our policy to put in barriers where there's accident histories. Then they put Cooper on the stand at trial, and they provide an affidavit from him, and he says, well, I'm sorry, I'm speaking fast. And he said, well, we decided in '99 not to put in barriers where there's accident histories. He wasn't on the committee. In fact, a year earlier, I deposed Cooper, and I tried to ask questions about this very document and this very subject, and they objected on foundation grounds. It's in Cooper's trial testimony. So this guy who they're claiming provides the basis for their decision, that's the sole evidence they provide for their supposed decision that they decided not to put in barriers where there's accidents. A year earlier, they object on foundation grounds when I try to ask them questions on those very topics.
Counselor, time's up.
I would like, if I have a minute for the cross appeal, I would like to do that.
Okay.
Thank you.
Your Honor, would you like him to address the cross appeal before I do my rebuttal?
Actually, Crosby, yes, you should do that so he has a chance to rebut. Sorry.
The Lunny case requires that Lunny should apply even though it's decided after this decision. The Lunny case requires government entities to search their databases. They didn't do that here. They basically, in response to the public records request, which occurred many, many months after the initial concealment. The public records request was January of '09, and Mike asked essentially the same question, how many crossover accidents have there been? And they said, we don't have that information. That not only violated what is now the law in Lunny, but it violated the spirit of the public records statute because they had the information, or at a minimum, they had the crash reports. They later produced the crash reports to Chris Acker in the Glazer case when he asked for them. So when a lawyer did a public records request asking for the reports, he got them. When the private citizen who's investigating the death of his wife asks for them, they say, we don't have that information. The true answer, and to comply with the spirit of the public records statute, would have been, Mr. Humphrey, we don't have a handy-dandy list of crossovers, but we've got the reports, and if you want to look at them, we'll make them available. They didn't do that. It was just as dishonest as the concealment that began in August.
Okay, thank you.
Trial judges do get it wrong. Otherwise, we wouldn't be here today. It's this court's responsibility to review these issues de novo. And as you pointed out, Judge Brown, there's cases that reject plaintiff's position that it's always a jury question, Thompson and Little. It's not always a jury question. If no
I
reasonable
agree
jury...
that the case that Walk, I think, points out it's almost always, or
Sure.
close to being always a jury question.
I don't disagree with that. And when you, especially in medical malpractice type cases where the injury is difficult to detect, I think those are probably more appropriate for the jury. But here, like Thompson, for example, that was a car hit a pothole and overturned.
Was this an injury that was difficult to detect, or?
No, not by no.
What
Not at
about
all.
the claim being difficult? What about, I mean...
That was the thrust of my question.
Yeah, the claim itself. Why wouldn't that be difficult to detect? I mean, how is your average person to know that a rollout, that the state would be complicit or have any duty with a rollover accident?
Well, it's not whether or not the claim is difficult to detect, it's whether or not you can connect the who to the what. Is that difficult to connect? So, for example, the walk was the dental example. Kowski was another medical malpractice case, I believe. But that's when it's difficult to figure out who may have had a hand in this.
Have there ever been accidents like this before, ever in the history of the United States?
Crossover accidents?
Sure.
Yeah. Mm-hmm.
Are there any people that have worked on those accidents that might be contacted?
Absolutely. Like plaintiffs' counsel, they're investigators. I'm sorry?
Engineers, people who know the physics of it. I'm just asking. I mean, are those people out there that could be contacted?
Sure, there's people that specialize in that. There's experts, engineering experts that specialize in this.
Is that part of the record? Is that, I mean, to what extent did the state present, I mean, I think where Judge Jones is going here is to the extent that there could have been an investigation by the statutory beneficiaries, as was discussed. To what extent did the state proffer any evidence that said, yes, you could have looked at the internet, you could have done this, you could have talked to so-and-so and so-and-so and so-and-so? Is that, because I don't want to get into too many hypotheticals here, what's actually in the record?
Sure. Well, I believe in the record, both Michael Humphry and Lynn Quinn testified that they picked up the phone and made requests for the accident reports and the photographs. That's what a reasonable person would do. When you lose a loved one in a situation like that, you would at least make those initial requests. Perhaps contact a lawyer who can get you in touch with experts. This is a very low threshold, and contrary to what plaintiffs' counsel has been saying to you today, I mean that's not always a jury question. There is a reasonableness standard, and here there is evidence that at least two of the plaintiffs knew enough to do something. They had enough knowledge to conclude that the state, that the absence of the median barrier was a condition that caused the accident.
Didn't the November 7th, 2008 letter state that the cause of the accident was the failure to do exactly that?
Yep, that's proof positive.
Okay, so we can assert it as a cause of the injury, but not use it. I mean, come on. What is the limitation on the ability to use that information if it's in the November 7th letter?
I don't understand the question.
It was horribly stated, and I apologize. But it just seems like when it serves our purpose, we're asserting that the November 7th letter adequately represented the blah, 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 blah. But when we don't want to do that, then it's not adequate somehow. I'm confused as to why the November 7th letter isn't more pivotal to the outcome of this case, given that they specifically assert the circumstances of the damage. Fair?
Fair.
Counsel, you've got 1 minute. I'll give you. You're out of
It is-
time, but I'll give you 1 minute to wrap up.
It is pivotal. Okay, I'll switch quickly to the immunity question. I think the arguments today illustrate why we have an immunity statute. Evanstead versus States held that the purpose of the immunity statute is to prevent litigants in courts from second-guessing policy decisions. We've heard a lot today about other accidents, and plaintiff's entire theory of the case below was that there should have been a median barrier because of these other accidents. Well, the state decided otherwise. They made a policy decision to only put median barriers based on median width and to not consider accident history. That's a policy decision, and because of that policy decision, they're immune from any liability that flows from that policy decision, including the absence of a median barrier at milepost 171.4.
Okay, counsel, thank you both for your very enlightening and well-done arguments, and we will take this matter under advisement and issue a decision in due course.